Another common way to distribute money from a tax-advantaged type of account, such as a 401k or an IRA, is a QDRO, which is a Qualified Domestic Relations Order. What that pertains usually is to some type of life event, a dissolution of marriage, maybe a person becoming deceased, sometimes a business separation or partnership separation. It's a judgment or decree or an order from a retirement plan to pay some type of marital property or settlement or spousal maintenance when there is a domestic account for an IRA or 401k. According to the IRS, there are certain rules about how that money is to be distributed. There's a cost basis associated with the account so that both parties have an advantage of the initial cost and both parties share in the tax distribution. There are many ways to have this done. First of all, it's usually separate to, but related to the settlement agreement of the underlying divorce or dissolution of marriage. Make sure you get good legal advice when you're crafting or drafting one of these type of agreements, because they may have long-lasting effects. So we're going to go through some of the factors to consider, some of the forms to fill out and examples of filings, and even some of the reasons why there might be choices made in how the money's distributed. Should be in a lump sum, should be maybe sent out on a monthly basis in terms of income, and it could affect your taxes and also legal reparations for that settlement. So let's jump into what the common problems are with a QDRO, the IRS treatment, and then maybe some forms that might be helpful to use in drafting this type of agreement. Here is an example of the type of form that the plan administrator might require for a QDRO distribution request. This happens to be the Principal Financial Group. This is a major plan administrator, and it's going to have some information such as the name of the employer, the plan name, plan number, phone number of the plan administrator, and then the name of the participant, who is the primary account holder, address, and is it active or terminated. This is very important, meaning that is the employee currently active with their contributions to a 401k, or are they receiving distributions and no longer an active employee. Vesting percentage is important. We'll get to that later, how the vesting may affect the distribution of the QDRO. And then the alternate payee. This is the party who will be receiving a portion of the distribution. And then below that, there's a selection whether or not the assets are going to remain in the underlying plan, or if they're going to be transferred to another brokerage firm or bank, financial institution, account numbers and percentage, that type of thing. This is an example of type of form. We'll look in a moment at a court filing that might be required to initiate the QDRO so that the plan administrator can distribute it correctly, not just to the plan holder, but also to the former or future ex-spouse of the plan holder. As part of the divorce or dissolution settlement, there is likely going to be a separate order as part of the settlement, but related to it as a separate document filed with the court. Here's an example of the type of order that's required. Normally the attorney or the plaintiff will prepare this order for a judge to sign. So make sure you get good legal advice from an attorney or from a consultant that is an expert in this type of law. So you're going to have the name of the jurisdiction, case number, the date. You're going to have an order related to a dissolution of marriage. So this is exactly what we talked about. This order is in conjunction with a final dissolution of marriage with the date. It'll have social security numbers to identify addresses. And then it'll have the jurisdiction of the court selecting to have the plaintiff substituted as an alternate payee for a certain percentage of the annuity benefit. Okay, so it'll have maybe a contract number, certificate number, and it'll tell what percentage of that security, whether it's a 401k, an IRA, an insurance policy, and it will have the court sign off on that percentage distribution. It's also important to have the terms and conditions of how that distribution happens. Is it going to be a lump sum at the time of order? Is it going to be distributed at the normal rate of distribution of the funds in retirement? Also, the tax implications might be laid out in this agreement. Keep in mind that none of the order terms can interfere or conflict with the distribution rules of that fund. For example, if a fund says that you can't change the type of investments in that fund, a court order can't undermine that in most cases. So keep in mind that the terms and conditions of this court order have to match and interlock with the dissolution of marriage, but also with the terms and conditions of the underlying benefits plan or the securities. And next we'll take a look at some common pitfalls and problems that come up when filling out these forms and setting up a QDRO. These types of filings, QDROs, can be complicated and tedious, so a lot of attorneys may outsource some of this to financial experts or specialists in this 401k arena, and making sure that it matches with the divorce agreement. So what are the common problems that you run into? The most common error that whether it's an attorney or a court will run into is it fails to clearly specify the amount or percentage of the benefit that should be paid to the alternate payee, the non-employee spouse in most cases. If it's less than clear what the breakdown is going to be, the plan administrator will reject it. So you could have a court order, you could have the form signed. If you submit it to the plan administrator and it's not clear how that's going to be distributed, the plan administrator will reject it and you'll have to start over. Usually this comes up when the participant spouse is not fully vested in the benefit plan. So if the QDRO divides the participant's interest by percentage but doesn't reference the amount of the vested interest, the QDRO is too ambiguous and they'll reject it. A similar problem comes up when the participant has taken a loan from the 401k. So if the employee or the plan participant has a loan that's been taken against the 401k, the QDRO has to make it clear whether the division is a percentage of the full amount or the balance equity after the loan amount. Another common problem is an improper requirement that the plan provide a form of benefit that's not provided for in the plan. Example of this is when a plan is invested in a security that's closed to new investors and the plan does not allow for an in-kind distribution. So the QDRO cannot make the plan administrator do something otherwise prohibited by the plan itself. The not as common of a problem, but very, very significant is the passage of time. So let's say, in reality, there's no time limit for the submission of a QDRO after a divorce. However, any delay can increase the risk of problems. If the participant takes a significant distribution from the plan prior to the approval of the QDRO, tracking down those funds that the plan participant took out could be problematic. So keep in mind that the divorce attorney or the QDRO expert will have to deal with all these issues and qualify what the solutions are prior to putting this paperwork together and getting the forms done. We'll put some links at the bottom of this video. Also, some forms will be included with the video. We'll take a look now at some rules and some expert advice on setting this up and approaching it with the divorce settlement in general and with the attorneys. Here are a couple final points from a really good CNBC article about QDRO filings and 401k assets, things to watch out for. It's important that you do not change the beneficiary before the divorce is final. The reason for that is, as long as you remain married, according to CNBC, account owners cannot name anyone other than a spouse without your approval. This matters if your soon-to-be ex passes away before the divorce is final. You might no longer have any rights to the 401k. The other common oversight is to make sure that the percentage is specified rather than the amount. Because let's say if somebody says the QDRO states that the receiving spouse gets $50,000, right? Well, what happens if the account has gains? If stocks go up, $50,000 might not be half of the value anymore. So putting a percent rather than the dollar amount sometimes is an advantage. For more information about QDRO and other general 401k questions, you can reach our website, 401kfunds.com, and there'll be some links and forms associated with this video at the website posted at the same time this video goes live.